B of the Constitution, as well as public participation. In essence, the petitioner has urged this court to hold that anything done in the manner suggested is unconstitutional. The respondents, led by the CS Interior, opposed the petition through replying affidavits and submissions. The CS argues that the petitioners have misunderstood and misconceived the government intention, and argues that there is no determination yet, as at the time the petition was filed, for deploying police officers to Haiti, and therefore the petition is premature, bad in law, and an abuse of the court process. The CS states that the government of Haiti, through the Prime Minister, appealed to the UN Security Council for deployment of a multinational force to stave insecurity and avoid human catastrophe. He says, following a meeting of Council of Ministers, a decision was made which adopted a resolution authorizing the call for assistance from international partners. In a letter of October 8, 2022, to the UN Security Council, which the UN Security Secretary passed on to the President, outlined options that were being suggested. One, for establishing a multinational police force, task force, and a multinational special force for purposes of securing the country, that's Haiti, from the rampage of criminal gangs. The CS Interior states that although the process had stalled due to absence of a country to lead that multinational security support mission, on 29th of July 2023, Kenya's Foreign Affairs Minister announced the country's acceptance to positively consider leading that force and to deploy 1,000 police officers to Haiti as an assistance mission. The Interior CS also states that on 21st September 2023, the President addressed the 8th UN General Assembly and underscored the urgent need for global solidarity and collaborative action to address the suffering of the people of Haiti. According to the CS, the UN Security Council passed the resolution earlier referred to on 2nd of October 2023, authorizing a deployment of multinational security mission headed by Kenya in close cooperation and coordination with the government of Haiti. It was to be for initial 12 months with a review after 9 months. On 3rd of October, the President issued a statement hailing the passing of that resolution. And on 8th of October, the CS Interior informed the public that the request to deploy police officers to Haiti would be subject to parliamentary approval in accordance with the Constitution. The Council, the National Security Council, passed a decision on 13th of October 2023 to deploy police officers to Haiti, and that decision was transmitted to the National Assembly, call it Parliament, for consideration under Article 240, Sub-Article 8 of the Constitution. The CS Interior therefore argues that the process of approving deployment was pending before Parliament when the petition was filed, and therefore the petition was not ripe, offended the doctrine of exhaustion and the separation of powers. They urge the court to dismiss this petition. This position was taken essentially by all the respondents in this case. The Law Society argued both ways. One, supporting that the sections impugned, that is 108, 7, 108, 109, were constitutional, but I argued that the council or anyone else cannot deploy police officers outside Kenya under Article 240, Sub-Article 8. To that extent, he supports both sides and therefore argues that the court should not allow the petition so far as deployment is concerned, because sections 107 and 108 of the Police Service Act have not been complied with. I have considered the argument in this petition. I've also read the Constitution and the law. I have distilled 3 questions for determination. Number 1, whether this petition is premature. Number 2, whether the sections impugned are unconstitutional. And 3, whether police officers can be deployed outside Kenya, and Article 248, or generally. Before delving into the main issues, I wish to dispose of a question that was raised by the Attorney General, that the President should not have been joined in these proceedings. The Attorney General, though not representing the President, has argued that the President cannot be sued in the manner he was, and cited the decision of the Supreme Court in the ND case. The Attorney General takes the position that the President has a constitutional immunity, and for that reason, civil proceedings cannot be brought against the President while in office. The petitioners argue that the President has been sued in his official capacity and not in a personal capacity, and for that reason, the office is properly sued. Whether the President can be sued or not is an issue that was dealt with in the ND case at the High Court and the Court of Appeal, where both courts held that the civil proceedings could be instituted against the President while in office if the President had acted outside the Constitution. On further appeal to the Supreme Court reversed that holding and held that civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during the tenure of office in respect of anything done or not done under the Constitution. The Supreme Court further held that Article 143, Sub-Article 2, grants immunity to the President by protecting the President from civil proceedings during his tenure in office for actions or omissions connected with the office and functions of that office. Following the holding by the Supreme Court, it is settled law that the President cannot be sued while in office for anything done or not done while in that office. For that reason, the petitioners could not lawfully include the name of the President in these proceedings, whether in his personal capacity or official capacity. In this respect, the President's name is struck out from these proceedings. Is the petition premature? The respondents argue that the petition is premature and offends the doctrines of ripeness, and they further argue that the petition offends the doctrine of exhaustion. According to the respondents, the petition was filed before Parliament determined the issue of deployment, and for that reason, this court should not decide, should decline jurisdiction and allow Parliament to consider the issue in exercise of its constitutional mandate under Article 118 and 119 of the Constitution and parliamentary standing orders. The petitioners and the Law Society take the opposite position, that this court has jurisdiction because the issues raised are on the constitutionality of actions complained of, and only the court can determine those issues. The petition was filed on 6th of October 2023 following the statement by the President and CS Interior that Kenya would deploy police officers to Haiti after the UN Security Council passed a resolution on deployment of multinational security service mission to Haiti. The statements from the President and the CS Interior gave the impression that a decision to deploy police officers had already been made. This prompted the petitioners to file this petition to challenge the actions. And the petition has filed 6 declarations that the act of deploying police officers to Haiti is unconstitutional, illegal, and void, that police officers cannot be deployed outside Kenya, and sections 107, 108, and 109 of the National Police Service Act are constitutionally invalid, among other reliefs. A reading of the petition and the relief sought that the petitioners seek from this court, it is clear that they seek interpretation of the Constitution and the law to determine whether the position taken by the petitioners is correct or not, whether police officers can be deployed out of Kenya, and whether the impunity sections are unconstitutional are issues that only the court can determine and not Parliament. Even if the respondents argue that a decision to deploy police officers to Haiti had not been made when the petition was filed, that alone cannot make the petition premature or violate the doctrine of ripeness. Regarding exhaustion, the position is that for the court to defer jurisdiction because of the doctrine of exhaustion, the alternative body, in this case Parliament, must be in a position to give an effective remedy to the petitioner's claims. Where the remedy would be inadequate or ineffective, the court cannot defer jurisdiction. In this petition, there is no doubt that Parliament cannot determine whether the impunity sections are unconstitutional. Parliament can also determine whether deployment of police officers outside Kenya is unconstitutional. Parliament's mandate is to approve or decline to approve deployment of police officers to Haiti. It cannot determine the constitutionality of the action. Unlike Parliament, the Constitution has, under Article 165D, 3D2 and 2, conferred on the court jurisdiction to check governmental action, and it is the solemn duty of the court to keep the organs of state within the limits of the power and the mandate conferred on them by the Constitution, determine whether any law is inconsistent with or in contravention of the Constitution, and whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution or the law. It is therefore within the mandate of the court to determine the issues raised in the petition in exercise of its jurisdiction. Even if it were possible for the court to defer jurisdiction because Parliament had not made a decision to approve deployment, Parliament would still not determine the rest of the issues in the petition. Furthermore, the issues in the petition cannot be split so that some are dealt with by the court while others are dealt with by Parliament. Where there is an allegation of violation or threat to violate the Constitution, it is within the court's mandate to determine the issue and not any other organ. The petitioners have instituted this petition on the strength of Article 2 on the supremacy of the Constitution and Article 3, which obligates every person to respect, uphold, and defend the Constitution, calling on the court to respond to the issues in the petition in exercise of its jurisdiction in Article 165.3. It is the finding of the court that the petition is not premature, does not offend the doctrine of ripeness, exhaustion, or separation of powers. The petitioners properly approached the court, heeding the call in Article 3.1 on their obligation to defend the Constitution. What about sections 107, 108, and 109? The petitioners challenge constitutionality of those sections in the National Police Service Act. Their case is that the sections fail constitutional test of validity because they allow deployment of police officers outside the country, contrary to the Constitution. In advancing their case, the petitioners take the view that the impunity section violates the purpose and intent of Article 240 of Sub-Article 8, which, according to the petitioners, only permits deployment of national forces outside Kenya. The petitioners take the position that the National Police Service functions within Kenya, and therefore police officers cannot be deployed outside the country. In allowing deployment of police officers outside the country, they argue The impugned sections follow the Constitution, and in particular Article 240 sub-Article 8A. The respondents take the opposite view and contend that the sections are constitutional, are not inconsistent with the Constitution. The Law Society partly agrees with the position taken by the respondents that the sections are constitutional and valid, but argues that deployment should only be done as permitted by the impugned sections. To resolve this issue, one must bear in mind the import of Article 2 sub-Article 4 of our Constitution, that any law that is inconsistent with the Constitution is void to the extent of the inconsistency, or any act or omission in contravention of the Constitution is invalid. A law enacted by Parliament must be consistent with the Constitution, short of which it will be declared unconstitutional. Before embarking on the discourse to ascertain the constitutional validity of the or either of the impugned sections, it is important to remind ourselves some of the principles that the court should bear in mind when determining the constitutional validity of a statute or its provision. A statute or provision is presumed constitutional, and it is the burden of the person alleging constitutional invalidity to prove that invalidity. Some decisions are there, you will have to see them. The National Police Service Act was enacted to give effect to Articles 238, 239, 243, 244, and 245 of the Constitution. Article 238 is on national security. That is, protection against internal and external threats to Kenya, its territory, integrity, sovereignty, its people, their rights, freedoms, property, peace, stability, and prosperity, as well as other national interests. Article 239 identifies national security organs, which are the Kenya Defence Forces, National Intelligence Service, and the National Police Service. The primary object of national security organs is to promote and guarantee national security in accordance with Article 238(2). Article 243 established a National Police Service consisting of National Police Service and Administrative Police Service. Article 244 then provides for the objects and functions of National Police Service. These are to strive for the highest standard of professionalism and discipline among its members, prevent corruption, and promote and practice transparency and accountability, comply with continuous standards of human rights and fundamental freedoms, train staff to the highest possible standards of competence and integrity, and respect human rights and fundamental freedoms and dignity, as well as foster and promote relationships with the broader society. Parliament may enact legislation establishing other police services under the supervision of the National Police Service and the command of the Inspector General of Police. That's Article 247. In other words, National Police Service supervises officers of the service, while the Inspector General commands the service. The impugned sections, that's Part 14 of the Act, are on reciprocal arrangement. Section 107 defines a reciprocating country as a country which the President may, on being satisfied that it has a law containing provisions reciprocal to those of Kenya, declare a reciprocal country for purposes of that Act. Notice should, however, be, for such declaration has to be published in the Kenya Gazette. Section 108(1) authorizes the President, on application by a government of the reciprocating country, to order a number of police officers he may consider necessary to proceed to the reciprocating country for service in that country for purposes of assisting the police service of that country in a temporary emergency. Under subsection 2, a police officer who is punished in the reciprocating country under any of the provisions of our Act, which are applied in the reciprocating country to that police officer while in that country, for an offense that is committed while in that country under the reciprocal arrangement, that officer will be deemed to have been punished in Kenya for a similar offense if committed in Kenya. Section 109, on the other hand, is the opposite of Section 108 and allows the President to apply to a country reciprocating for police officers to come to Kenya under reciprocal arrangement similar to those in Section 108, subsection 1. The petitioner's case is that the impugned sections are constitutionally infirm because they allow deployment of police officers outside Kenya, contrary to Article 243, sub-Article 3. I have read that article, which establishes a national police service. Sub-Article 3 states that national police service is a national service and is to function throughout Kenya. Subsection 3 does not state that the police officers serving within the national police service cannot be deployed outside Kenya, but that the service shall function throughout Kenya. My understanding of the import of that article is that National Police Service functions in all areas within Kenya to provide security to its people, to its people and their property. As a national police service, National Police Service serves the whole country and not specific areas, counties, or regions. Otherwise, it would not be a national service. I have also read Article 238, 239, 244, and 247, which the National Police Service Act gave effect to. None of those articles state in express terms or by implication that police officers cannot be deployed outside Kenya. The petitioners, having not shown that these articles expressly or by necessary implication prohibit the deployment of police officers outside Kenya, they cannot rely on Article 243, sub-Article 3 to support the argument that police officers cannot be deployed outside Kenya, simply because the service functions throughout Kenya. The language used in Article 243, sub-Article 3 does not support the petitioner's assertion. The petitioners also cite Article 240, sub-Article 8 on their argument that the sections are unconstitutional because they allow deployment of police officers outside the country. In their view, only national forces can be deployed outside Kenya. I have again read Article 240, sub-Article 8, and I find nothing prohibits deployment of police officers outside Kenya. I will, however, say more on this article later in this judgment. Article 243, sub-Article 4 mandated Parliament to enact legislation to give full effect to Article 243. Parliament then enacted the National Police Service Act in response to that mandate. Sections 107 to 109 provide for reciprocal arrangement and when and under what circumstances national police officers may be deployed outside Kenya. It is for that reason that the Law Society parts ways with the petitioners on deployment of police officers out Kenya. The Law Society takes the position that the impugned sections are constitutional since they provide a mechanism under which reciprocal arrangement be undertaken. That is, any reciprocal arrangement must comply with the procedure in Article 107, 108, and 109 for deployment out of the country or into the country. For instance, a notice must be published in the Kenya Gazette on the reciprocating countries for purposes of accountability. Article 2, sub-Article 4 of the Constitution is unequivocal that a law will be void if it is inconsistent with the Constitution. Where a provision is said to be inconsistent with the Constitution, the inconsistency must be plain and clear when the provision is laid against the article of the Constitution it is said to be inconsistent with. Have I gone through the various articles of the Constitution? The sections are said to be inconsistent with. I have not been able to find any inconsistency between the impugned sections and those articles. Where it is alleged that a statutory provision is inconsistent with the Constitution, the court embarks on a fact-finding by laying those sections against the articles of the Constitution said to be offended and determines the infirmity, if any. Invalidity may be on the purpose for which the statutory provision was enacted or the effect of its implementation. If the court finds infirmity or inconsistent in the challenged sections, it has no option but to declare those sections invalid as decreed by Article 2, Sub-Article 4. The petitioners have not demonstrated any invalidity in the impugned sections. In any case, the import of the impugned sections is to allow mutual reciprocity between Kenya and other countries. Section 109, for instance, mandates the President to request a reciprocating country to send police officers to Kenya where circumstances similar to those under Section 108 exist. The benefit would be to both reciprocating countries, and for that reason, I see no inconsistency. Deployment of police officers. The main gist in this petition is whether police officers can be deployed outside the country under Article 240, Sub-Article 8 of the Constitution. The petitioners and the Law Society argue that because National Police Service functions within Kenya, its officers cannot be deployed outside Kenya under Article 240, Sub-Article 8. Their position is that only national forces can be deployed outside Kenya, but not National Police Service because it is not a force. The petitioners and Law Society assert that Article 240 only allows the Council, with approval of Parliament, to deploy national forces outside Kenya for regional or international peace or other support operations. The national forces referred to in Article 240, Sub-Article 8, they argue, does not include National Police Service. The respondents maintain that a holistic reading and interpretation require that Article 240, Sub-Article 8 be read alongside Article 239 of the Constitution. In their view, national forces referred to in Article 240, Sub-Article 8 refers to the Kenya Defence Forces, National Intelligence Service, and National Police Service collectively. The respondent assert, therefore, that the Council has power to deploy any of the three security organs out of the country under the circumstances contemplated in Article 40, Sub-Article 8A. The decision on this issue turns on the interpretation of Article 240, Sub-Article 8. In determining this issue, the Court must be aware of its obligation under Article 159, Sub-Article 2E, when exercising its judicial authority, including that of interpreting the Constitution, to ever have present in mind the obligation to protect and promote the purposes and the principles of the Constitution. Similarly, Article 259 calls on the Court to adopt an interpretive approach that promotes the purpose, values, principles of the Constitution, advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. The Constitution should also be holistically and purposefully interpreted in a manner that advances its purposes, gives effect to its intent, and illuminates its contents. There's decisions there I've referred to, which you will also see. In some decision from India, one judge who was writing for that Supreme Court cautioned those on whom the duty to interpret a constitution falls, and this is what he said. We can always find some reason for bending the language of the Constitution to our will if we want. But that would be rewriting the Constitution in the guise of interpretation. We must also remember that the Constitution is an organic instrument intended to endure, and its provisions must be interpreted having regard to the constitutional objectives and the goals, and not in the light of how a particular government may be acting at a given point of time. Judicial response to constitutional interpretation must not suffer from the fault of an emotionalism or sentimentalism, which is likely to cloud the vision when judges are confronted with issues of monumental importance. End of quote. This court will therefore proceed on the basis of the above principles, determine the objectives and the goals of Article 240 sub Article 8, and give true meaning to it. Article 240 establishes the Council consisting of the President, the Deputy President, the CS responsible for defense, the CS responsible for foreign affairs, the CS responsible for internal security, the Attorney General, Chief of the Defense Forces, the Director General of National Police Service, and the Director General of the National Intelligence Service and the Inspector General of the National Police Service. The Council exercises supervisory control over national security organs, Kenya Defense Forces, National Security Intelligence Service, National Intelligence Service, and National Police Service, and performs any other functions prescribed by national legislation. The objective and goal of Article 240 sub Article 8 was to provide for which security organs can be deployed outside the country, by who, and under what circumstances. In that spirit, the article identified national forces for deployment outside the country and assigned the mandate to deploy those forces to the Council, subject to approval by Parliament. The forces can only be deployed out of the country for regional or international peace or other support operations. But petitioners and Law Society argue that the mandate of the Council does not include deploying National Police Service out of the country. They hold the view that National Police Service is not a force for purposes of Article 240 sub Article 8. The respondents take a contrary position, arguing that the Council can deploy the three national security organs, Kenya Defense Forces, National Intelligence Service, and National Police Service, only subject to parliamentary approval. There is no debate that the mandate conferred on the Council is to deploy national forces outside Kenya with approval of Parliament. The words national forces used in the Constitution are not defined. The position taken by the petitioner and the Law Society is that the National Police Service is not being a force, cannot be deployed by the Council under Article 240, sub Article 8. When called upon to interpret words used in the Constitution or statute, the general principle is that if the words used are clear and unambiguous, they should be given their ordinary meaning. In interpreting the statute, both context and the context are important. They are the basis of interpretation, because if the text is the texture, content is what gives the color. The court should also examine every word used in a constitution or statute in its context and use context in its widest sense. Kenya has no forces other than the defense forces comprising Kenya Army, Kenya Air Force, and the Kenya Navy, otherwise called the military. In the three national security organs mentioned in Article 239(1), only Kenya Defense Forces are forces. The other two national security organs, National Intelligence Service and National Police Service, are services. From the constitutional text, one cannot legitimately argue that national security organs are the national forces. Even though heads of those three security organs are members of the council, one cannot also argue that the national forces include National Intelligence Service and National Police Service. Given that the Constitution permits deployment of forces and applying a purposive and holistic interpretation of that article, I find and hold that national forces used in Article 240 sub-Article 8 mean Kenya Defence Forces, so that the Council may, with approval of Parliament, deploy Kenya Army, Kenya Air Force, or Kenya Navy as national forces outside the country for regional or international peace or other support operations, depending on the mission needs. If the intention of the framers of our Constitution was that the Council should deploy defense forces, National Intelligence Service, and National Police Service, they could have easily stated so and mandated the Council to deploy national forces and services, or better still, national security organs, to capture that intention. In that respect, it is the holding of this court that the Council cannot deploy National Police Service out of the country under Article 240 sub-Article 8, because the mandate of the Council is to deploy forces, that is Kenya Defence Forces, for regional or other international support operations, are not National Police Service. That the Council can only deploy Kenya Defence Forces under Article 240 sub-Article 8 find support in the Kenya Defence Forces Act, where Section 18 of the Act reiterates the functions of the Council in relation to Kenya Defence Forces and states the National Security Council shall, with respect to the Defence Forces, pursuant to Article 240 sub-Article 8, 6 and 8 of the Constitution and the provisions of the National Security Council Act, exercise supervisory control and perform the following functions. C, being deployed defense forces outside Kenya with approval of Parliament for regional or international peace support operations or other support operations. B, approve with the approval of Parliament the deployment of foreign forces into Kenya. The Kenya Defence Forces Act makes it clear, using the same word used in the Constitution, that the Council may deploy defence forces outside the country with the approval of Parliament. When enacting this Act, Parliament appreciated that Article 240 sub-Article 8 permits the Council to deploy defence forces outside Kenya and captured that intention in the Kenya Defence Forces Act. Unlike the Kenya Defence Forces Act, Section 6(2) of the National Police Service Act provides that the Council may deploy the service, that's National Police Service, or any other part of the service that would include any other force that may be, service that may be created in the defense of Kenya during an emergency. That is the only time the National Police Service Act mandates the Council to deploy National Police Service. Section 6 subsection 3 is also clear that for purpose of deploying the service in case of emergency, that's by National Security Council, the procedure under Article 58 of the Constitution shall apply. Other than as provided under Section 6 subsection 2 and 3, the Council has no mandate to deploy National Police Service even within Kenya. It is important to note that Parliament did not import Article 240 sub-Article 8 into the National Police Service Act or National Intelligence Service Act, as it did with regard to Kenya Defences Act. In not doing so, Parliament recognized that the Constitution did not contemplate deployment of those services outside the country. The petitioner maintained that because the way the Section 6(1) is worded, deployment of the service can only be within Kenya, and therefore Sections 107, 108, and 109 are inconsistent with Article 240 sub-Article 8. As already have stated earlier in this judgment, Article 240 does not preclude deployment of national police service outside Kenya. Similarly, Section 6, subsection 1 does not preclude deployment of the service outside the country. Sections 107 and 108, that's part 14 of the Act, properly provide how the service may be deployed outside the country, when and by who. To be clear, Article 240 does not mandate the Council to deploy police officers outside Kenya. Deployment should be as provided for in Part 14 of the Act and only to a reciprocating country. The respondent argue that no further legislation was contemplated to give effect to Article 240 sub-Article 8 on the deployment of national forces. That may be so, but it cannot be said that Parliament was wrong when it enacted the Kenya Defence Forces Act, reiterating the words in Article 240 sub-Article 8 that the Council may deploy defence forces out of the country subject to parliamentary approval. The petitioners and the Law Society argue, which is not contested, that there is no reciprocal arrangement between Kenya and Haiti, and for that reason, there can be no deployment of police officers to that country. There can be no legitimate deployment of police officers to Haiti, either under the National Police Service, without complying with Section 107 and Section 108. I've read the replying affidavit by the CS Interior and the text of Resolution 266 of the UN Security Council. They confirm that Kenya's Foreign Affairs CS pledged Kenya's willingness to contribute forces towards assisting Haiti to restore security and prevent alarming humanitarian crisis. Kenya also offered to lead the multinational security support mission to Haiti. It's no doubt great honor for Kenya to offer to lead the multinational security support mission for Haiti. Similarly, Kenya has an obligation to join the International Community of Nations in assisting Haiti as part of its international obligations. However, an endeavor towards that end must be in accord with the Constitution and the law. The effort, and in particular the attempt by the Council to deploy police officers to Haiti, fails constitutional and legal foundation. So, in conclusion, having considered this petition, responses, arguments by the parties, and read the Constitution and the law, I come to the conclusion that first, the petition is not premature, does not offend the doctrine of rightness, exhaustion, or separation of powers. The petitioners properly moved the court in defense of the Constitution as the acts complained of were a threat to violate the Constitution and the law. Second, Sections 107, 108, and 109 of the National Police Service are constitutional. There is no inconsistency between those sections and the Constitution. Third, National Security Council has no constitutional or legal mandate to deploy National Police Service officers outside Kenya under Article 240 of Sub-Article 8 or any other law. Article 2, Sub-Article 4 of the Constitution invalidates any act or mission that contravenes the Constitution. In that regard, any purported decision by the National Council or any other state officer to deploy police officers outside Kenya and any other action taken by any other state organ or state officer in furtherance of that decision is invalid and null and void. And these are the final orders that come. Number one, a declaration is hereby issued that sections 107, 108, and 109 of the National Police Service Act, which provide for deployment of police officers outside the country under reciprocal arrangement to reciprocating countries, are constitutional and valid. Two, a declaration is hereby issued that National Security Council has no mandate to deploy police officers outside Kenya under Article 240 Sub-Article 8 of the Constitution or any other law. A declaration That's number 3, is hereby issued that any decision by any state organ or state officer to deploy police officers to Haiti and any other action, any further action or steps taken by any state organ or state officer in furtherance of such a decision contravenes the Constitution and the law and is therefore unconstitutional, illegal, and invalid. An order is hereby issued prohibiting deployment of police officers to Haiti or any other country otherwise than in compliance with Part 14, that is Sections 107 and 108 of the National Police Service Act. And finally, this being a public interest litigation, I make no order on costs. Thank you.
Lordship, on behalf of the Law Society, we are most grateful for thank you. Lord, on behalf of the past and that importance, we wish to apply for a copy of the decision and certify copies of the decision. And we thank you for your decision.
Minister?
Keep talking.